An 8-1 Supreme Court decision just changed the rules every carry case now lives under. And if you still think the old playbook is enough, you could misunderstand where you can carry, when you can carry, and what happens if a state says no. Quick question before we continue. Are you subscribed? Because what I'm about to explain could keep you from trusting bad internet advice and walking straight into a criminal charge. Hit that button now, and let's get into it. Here's what just happened, and here's why this title is not just hype. Most gun owners heard about the big 2022 Bruen case and thought, that's it, game over, states can't block carry anymore. But that was only the first wave. Bruen said New York could not force regular people to prove some special need before carrying in public. In simple terms, the court said you do not need to be rich, famous, threatened, or connected to exercise your right to carry for self-defense. If you are a normal law-abiding person, the state cannot treat your right like a favor. That was huge, and it changed carry law across the country almost overnight. May issue states got hit hard because those systems gave government officials too much room to say yes to one person and no to another. But here's the crazy part. After Bruen, a lot of states did not just give up and walk away. They changed tactics. Instead of saying you cannot get a permit, they started saying fine, maybe you can get one, but you still cannot carry in this place, that place, and almost every other place. So the fight moved. It stopped being only about who gets a permit. It became about where you can carry once you have one. That is where the real confusion exploded. Some states said private property open to the public was off limits unless the owner gave express permission. Think restaurants, stores, banks, and parking lots. Some states expanded sensitive places lists so far that people started asking, wait a second, if I can't carry in most normal public places, do I even have a real carry right anymore? And that question matters to you because this is where most people get it wrong. They think one Supreme Court case solved everything. It did not. Bruen gave gun owners a strong wind, but it also launched a second battle over what kinds of restrictions still survive. Lower courts then had to figure out how to apply the new test, and many of them did it in very different ways. Some judges read Bruen very strictly. They wanted a nearly perfect old-time match from American history before they would allow a modern gun law. Other judges said, no, that is too rigid. History gives principles, not copy and paste answers. So now you had chaos. One court would strike down a law, another court would uphold something very similar. Gun owners, lawyers, police, and even judges were all asking the same thing. What exactly counts as a valid modern carry restriction now? That is why the 8-1 decision matters so much, because the court did not just rule on one person, it corrected the way lower courts were reading the whole test. And when the court changes the method, it can change the outcome of carry cases all across the country. First thing you need to understand is that the 8-1 case was not a simple carry permit case. It was United States versus Rahimi. The issue there was whether a person under a domestic violence restraining order could be barred from having guns. At first, some gun owners ignored it. They thought, the case is about possession, not carry. That case is about a bad guy, not me. But wait, there's something even more important. The biggest impact of Rahimi was not just the result. It was the rule the court used to get there. The court said the Second Amendment is real, strong, and important, but it also said the right is not unlimited. Then it explained something lower courts badly needed to hear. A modern gun law does not have to be a perfect historical twin to an old law from 1791. It does not have to be a dead ringer. The real question is whether the modern law is relevantly similar to historical tradition and why it exists and how it burdens the right. That sounds legal, so let me say it in plain English. The court basically said this: stop demanding a photocopy from the founding era. Look at the principle. Ask why the old law existed. Ask how much it burdened the right. Then compare that to the modern law. This shocked a lot of people because some lower courts had been acting like if they could not find one old law that looked almost exactly the same, the modern law had to fall. Rahimi pulled them back from that edge. The court said the law is not trapped in amber. In other words, modern problems can still be addressed as long as the government can point to a real historical tradition that supports the principle behind the rule. Now, this is where it gets interesting for carry law. If a court no longer needs an exact twin from history, states suddenly have a better shot at defending some modern restrictions. Not all of them, but some of them. That means the carry battlefield changed again. The question is no longer just, can the state find the same exact law from 1791? Now the question is, can the state show a historical pattern or principle that is close enough in purpose and burden? So if you carry, you need to stop thinking in slogans. Bruen ended all carry restrictions is not true. The government can do whatever it wants is also not true. The real answer sits in the middle, and that middle ground is where people get burned. If you're finding this helpful, imagine what you'll learn in my next video about the exact words that can protect you when an officer starts asking questions about your gun. Subscribe so you don't miss it. Let me break down what Rahimi means in the real world. Number one, dangerous person laws are on stronger ground than many people expected. The court said that when a person has been found by a court to pose a credible threat to someone's physical safety, temporary disarmament can fit with the Second Amendment. That does not mean every gun ban is valid. It does mean the court is willing to let government act against clearly dangerous people if there is enough history behind that principle. Number two, location rules are now being judged in a more practical way. Bruen already said some sensitive places can be off limits, like schools and government buildings, but it warned states not to call every crowded place sensitive just to kill the right in practice. Rahimi did not erase that warning. What it did was tell lower courts to use analogies more carefully and more realistically. Number three, the fight over private property is now one of the biggest carry fights in America. Here's what that means. Some states, like Hawaii, passed laws saying if private property is open to the public, carrying there is banned unless the owner clearly says yes. So instead of the default being carry is allowed unless the owner says no, the state flipped it. No carry unless the owner says yes. Imagine you have a valid concealed carry permit. You stop for gas. You go into a sandwich shop. Then you walk into a bank lobby. Under that kind of rule, you might be committing a crime simply because the owner never gave express permission. That is the part nobody's talking about enough. A permit holder can go from legal to illegal just by stepping through the wrong doorway. Now, quick legal note, this is educational information, not legal advice. Always consult an attorney for your specific situation. And yes, the Supreme Court is already looking at this broader issue. The Hawaii case, Wolford v. Lopez, is about whether the state can presumptively ban licensed carry-on private property open to the public unless the owner gives express consent. During oral argument, several justices sounded skeptical of Hawaii's position. That matters. They asked why firearms were being singled out. They questioned whether the state had flipped the default too far. They pushed on weak historical examples. And they seemed concerned that if the state can do this almost everywhere, then the right to carry starts to look fake in daily life. But here's the warning. Skeptical questions at argument are not a final ruling. A lot of people watch oral argument clips, get excited, and start acting like the law already changed. Don't make that mistake. Until the court issues an opinion, the current rule in your state is still the rule you can be arrested under. Here's a hypothetical example to explain this. Let's say Jake has a valid permit. He watches a video online saying the Supreme Court is obviously about to strike down private property carry bans, so Jake starts carrying into places where state law still says he cannot. Then a police officer gets called. Jake says, but the justices sounded on my side. That will not save him that day. Courts deal with actual law, not your favorite prediction video. This is why legal timing matters, just as much as legal theory. You might be morally right and still legally exposed if you move before the rule actually changes. When I found that out years ago in this field, I couldn't believe how many people confuse likely with legal. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the gun owners who want the update before the headlines twist it. Click subscribe and stay ahead of the next ruling. So what should you do with all this? Let's make it simple. First, know your state's current default rule on private property. In some places, no sign means you may be okay. In others, no sign does not help you. The law may still treat the location as off limits unless the owner says yes. That difference is massive. Second, do not assume your permit solves everything. A permit answers one question. Are you licensed to carry? It does not answer every other question. Where can you carry? Does the place serve alcohol? Is it private property open to the public? Is there a posted sign? Are there special state restrictions on events, parks, transit, or government buildings? Those are separate issues. Third, stop treating social media comments like legal research. Most people think, I saw one guy say, signs do not matter in my state. The truth is, one bad comment section can ruin your month, your money, and sometimes your rights. Check actual state law, check actual current court rulings. If needed, pay a lawyer for one clean answer. Fourth, understand the difference between a constitutional win and a practical win. Bruen was a constitutional win, but some states answered with long lists of restricted places. So a person could feel like they won on paper and still lose space on the ground. That is why the next carry cases matter so much. They will decide whether states can make carry legal in theory, but nearly impossible in practice. Fifth, watch the court's language carefully. If the justices say states cannot turn most public life into a gun-free maze, that helps permit holders. If they say states have broader power to set default no-carry rules on private property, that helps states. And because Rahimi told courts to look for relevant similarity rather than exact matches, both sides are now fighting over the level of generality. That sounds boring, but it is huge. The side that frames the history better often wins. And here's one more mistake people make. They hear 8-1 and think the court is united on everything gun-related. No, Rahimi was a strong majority, but the justices did not all agree for the same reasons. Some wrote separately. Some stressed the ruling was narrow. Some basically admitted Bruen has been hard for lower courts to apply. That tells you the law is still moving. The court is still building this area piece by piece. That means you should expect more changes, not fewer. If the court decides the Hawaii case broadly, it could reshape how private property carry rules work nationwide. If it decides narrowly, the fights will keep going state by state. Either way, the carry rulebook is not settled. It is being rewritten in real time. This next update could hit the second the court drops its carry opinion. Subscribe now because my next video will break down exactly what changed, what stayed the same, and what you need to do before you trust your permit in the wrong place. So here's the bottom line. The 8-1 decision did not erase carry laws overnight, but it did rewrite how courts judge them. Bruen opened the door. Rahimi changed the measuring stick. And the next big carry case could decide whether your permit protects you in the places you actually go every day. If you care about staying armed, staying lawful, and staying out of avoidable trouble, subscribe right now and stick with this channel. I spend the time digging through this stuff so you do not have to learn the hard way. And one last simple reminder. Laws change, facts matter, and your exact situation matters. This video is for education only, not personal legal advice.